So I'm going to let Mike present on what was entered in Congress.
So yesterday, HR6134, the Truth in Trials Act.
Hold on, HR6134. We got to get into the notes. That's why I'm slowing you down there.
No problem. It's actually very short for a change, so I can read the whole bill in a moment.
As law should be. Let's hear it.
It's called the Truth in Trials Act. It was introduced in the House yesterday.
I heard about it.
To amend Title 18 United States Code to provide an affirmative defense for the medical use of marijuana in accordance with laws of the various states and for other purposes. In the House of Representatives, July 17, 2012. I'll just read the sponsors for the sake of it's not that long. Mr. FARR for himself, Mr. Paul, Mr. Cohen, Mr. ROHRABACHER, Mr. Frank of Massachusetts, Ms. Lee of California, Mr. HINCHEY, Mr. Stark, Mr. BLUMENAUER, Mr. MORAN, Mr. GRIJALVA, Mr. POLIS, Ms. WOOLSEY, Mr. WAXMAN, Mr. AMASH, Mr. RANGEL, Mr. McGovern, Mr. George Miller of California, and Mr. NADLER introduced the following bill, which was referred to the Committee on Judiciary.
We have friends in Judiciary. That's good.
Cool. On the federal level.
A bill to amend Title 18 United States Code to provide affirmative defense for the medical use of marijuana in accordance with the laws of the various states and for other purposes. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Section 1, short title. This act may be cited as the Truth in Trials Act. Section 2, providing an affirmative defense for the medical use of marijuana, seizure of property. A. In general, Chapter 221, you don't have to write all this.
No, he'll just forward that to you.
Okay.
Don't try to keep up with this.
Just write the bill number down. All minutes really have to be. All minutes really have to be, just so everyone's clear, because anyone could be put in the position of doing minutes. Is votes, subjects, and just really, minutes should never be more than 1 to 2 pages, even for 4-hour meetings. Slow down.
Thank you.
Go ahead.
A. In general, Chapter 221 of Title 18 United States Code is amended by striking Section 3436 and all that follows through the end of the chapter, inserting the following. Section 3436, affirmative defense for conduct regarding the medical use of marijuana, seizure of property. A. Any person facing prosecution or proceeding for any marijuana-related offense under any federal law shall have the right to introduce evidence demonstrating that the marijuana-related activities for which the person stands accused were performed in compliance with state law regarding the medical use of marijuana, or that the property which is subject to a proceeding was possessed in compliance with state law regarding the medical use of marijuana. B1. It is an affirmative defense to a prosecution or proceeding under any federal law for marijuana-related activities, which the proponent must establish by preponderance of the evidence that those activities comply with state law regarding the medical use of marijuana. 2. In a prosecution or proceeding for a marijuana-related offense under any federal criminal law, should a finder of fact determine, based on state law regarding the medical use of marijuana, that a defendant's marijuana-related activity was performed primarily but not exclusively for medical purposes, the defendant may be found guilty of an offense only corresponding to the amount of marijuana determined to be for non-medical purposes. C. Any property seized in connection with the prosecution or proceeding to which this section applies, with respect to which a person successfully makes a defense under this section, shall be returned to the owner not later than 10 days after the court finds the defense is valid, minus such material necessarily destroyed for testing purposes. D. Any marijuana seized under any federal law shall be retained and not destroyed pending resolution of any forfeiture claim, if not later than 30 days after seizure the owner of the property notifies the Attorney General or a duly authorized agent of the Attorney General that a person with an ownership interest in the property is asserting an affirmative defense for the medical use of marijuana. E. No plant may be seized under any federal law otherwise permitting such seizure if the plant is being grown or stored pursuant to a recommendation of a physician or an order of a state or municipal agency in accordance with state law regarding the medical use of marijuana. F. In this section, the term state includes the District of Columbia, Puerto Rico, and any other territory or possession of the United States.
Possession.
The clerical amendment, the table of sections at the beginning of Chapter 221 of Title 18 United States Code is amended.
Stolen by.
Yeah, the rest of it. So that's basically it. It's really, I think it's pretty good.
Yeah.
So.
Sounds bad. It sounds like I think my plants.
Oh, okay. Question?
Yeah. Now, it does say, if I'm hearing that correctly, that 6134 is, been approved by House of Representatives.
No, it hasn't. What it has been is introduced. So upon introduction, it's just like at City Hall. You introduce, then it has several readings, amendments, it gets argued on the floor. It's a bill, and then unlike City Hall,
Don't forget attached unrelated legislation to it.
attach unrelated legislation to it also happens in the process.
Right.
But as it stands, it's excellent. I think it really answers a lot of the issues that we're having.